Art Ritchie and Keith Lyons, candidates for Department H Family Court. And Art Ritchie, I will point out, is the incumbent. And gentlemen, let me read some preliminary rules for you, if I may. Candidates are allowed a minute and a half to introduce yourselves. Panel members are allowed 30 seconds to pose a question. However, I sometimes give them a little liberty. Candidates are allowed 1 minute to answer. Panel members are allowed one question. The question may be to one candidate or all candidates, and we would like a yes or no response. Sometimes that is difficult. I will determine whether I give you 30 seconds or 1 minute to respond. This is not a forum for personal grievances. Panel members will please keep their questions generic for the candidates. And candidates, do not mention other candidates in your responses. And again, I will remind you that we do have an incumbent judge, so any questions pertaining to cases will be disallowed. That being said, I will let's see what we got here. Mr. Ritchie, would you like to please introduce yourself? You have a minute and a half.
Thank you. It's an honor to be here. It's been incredibly important to me to have the support of veterans in politics in the past, and I made a point to be here today because I want the endorsement of the veterans in politics again this year. In fact, as soon as this interview is over, I'm going to go back on the highway, go back to the semifinal game that we had at 5:30 in St. George, Utah with my team. I was born in rural Georgia where my dad was in the Ranger School. My dad was regular Army. My grandfather also regular Army, and he passed serving his country in World War II. I never went to school anywhere more than 2 years of my life until I went to the University of Virginia. I graduated from the University of Virginia, went to law school in Washington, D.C., and I moved to Nevada 27 years ago. I practiced law in Clark County, Nevada, until I was evaluated and recommended to Governor Gwynn in 1999 and appointed to this job. So for 14 years, I served as the district judge in Department H here in Clark County. I was reelected in 2000, 2002, and 2008. And this year I'm running again for another term. I've had an opportunity and a privilege to manage a civil domestic calendar, a calendar that I think is one of the most important that we do. I have a wide background in the law, and many of the people that have known me over the years have asked me, why family law? And I think that it touches our community as one of the most important that we have. I appreciate your support. Thank you.
Thank you, Mr. Ritchie. Mr. Lyons, a minute and a half to introduce yourself, please.
I'd like to thank the Veterans in Politics for setting this process up. I have supported the veterans through my practice. Just in the last 8 years, I've given more than $100,000 per more to veterans in my practice. It is something that I think as a community we owe the veterans to support them, especially when they come back with troubles from their tours of duty. In my family, my dad was not eligible for the service of World War II because he was too young, but post-World War II went to the Oregon National Guard. I was raised with respect for the military. My grandfather was a CV on one side. My other grandfather was in the charge of the port of Portland, that's Portland, Oregon, during World War II. Son was bred into our family. While my dad was in the military when I was growing up, he was a rural pastor, so I'm trying to remember from when I did my bar application whether I lived in 17 places between 12 and 29, or whether I lived in 12 places and worked 17 different jobs prior to law school. I honestly can't remember at this point. I have practiced a mixed practice in family law, bankruptcy, labor law, and criminal law, representing primarily individuals. I believe my experience helps me with my family law cases, which is about 40% of my practice, and has been for the last 21 years. That experience helps me deal with the tremendous issues facing families.
Thank you, Mr. Lyons. Just for your golden benefit, because the panelists have already heard me step all over them when it's their time to stop. It is not because I'm being disrespectful or rude, it's in the best interest of time. So just be mindful of that. It is no disrespect to either one of you. So I apologize ahead of time. I'm not a professional moderator.
You're doing it.
But he does enjoy cutting people off.
That being said, Ms. Manharis, would you ask the first question, please?
Yes, this is directed towards Mr. Ritchie. I've seen spiteful mothers try to use their children's father's service in the military as a means to deem the father unfit due to things such as PTSD. How much weight do you give these accusations, and what is your course of action in these types of situations?
First of all, mental and physical health of any parent is a relevant issue in custody. It's one of the mandatory considerations under best interest. we evaluate all of those allegations equally. I know my dad was deployed twice to Southeast Asia. I don't have to go very far. My marshal of 14 years has had 3 deployments. This last one is retired as an E9. I've seen how it affects families, both in my family and in others. You evaluate it and you affect the proof. If there is a treatment or post-traumatic stress disorder issue, then you help them work through it, whether they're a veteran or whether they're not a veteran. But it is an important matter to protect the fundamental rights of parents, whether they're, I mean, there's no such thing as a perfect parent. Everyone has issues. And so, obviously, the veterans are facing many issues, especially economic issues, and they would be a fair consideration in any custody case.
Thank you very much. Ms. Fee, your next question, please.
Okay, I'll ask this for both candidates. In a custody case where both seem fit, but one's claiming the other uses medical marijuana as their reasoning for not splitting custody, how do you come down on that?
Mr. Lyons, 1 minute, please.
Well, I differ from Judge Ritchie on this issue because I believe that one of the biggest problems facing our children are illegal drugs or legal drugs used illegally in the family situation. And while medical marijuana is legal, you still have to deal with the fact that that parent, depending on their usage, is stoned when they have custody of the child. And you have to weigh how much marijuana they're using, what is their physical shape or ability when they're using the drug, when are they going to have visitation with the child in making a custody decision. Because even though it is a legal drug, if it's legal marijuana, they may still use it in a way that impairs their ability to properly parent.
In the 14 years I've been on the bench, I've seen a lot of evidence about marijuana, and I keep an open mind about it. I understand there to be a need to draw a relationship between the use of marijuana and any abuse and neglect of children. And many times there is no relationship, and many times there are legitimate uses for that drug, whether you're dealing with multiple sclerosis or whether you're dealing with other pain management issues. And so, in as much as this is an evolving area of the law, it's something that you study, it's something that you make sure that you're aware of as far as, but it isn't one bright line. It isn't, well, you're going to lose your kids because you happen to be using a controlled substance. In fact, I think that you can just look at the papers and see that this is a matter of debate, not only in this state, but around the country.
Thank you.
Mr. Ross, can I just have one yes or no follow-up?
In the microphone, please, Ms. Fee.
Okay, so I understand both your positions, but on if they were taking a heavy prescription drug quite a bit, would you give that the same weight as being under the influence as marijuana, yes or no?
30 seconds. Okay, yes or no, Mr. Lyons?
And that actually isn't a yes and no question because you have to weigh the drug, you have to weigh its impact on their ability to parent, and you have to weigh whether they are legally using the drug in a properly prescribed manner by a doctor.
Mr. Ritchie, 15 seconds, please.
I agree with Mr. Lyons. There has to be a relationship, and certainly the abuse of Oxycontin or some prescription medication or methamphetamine has direct relationships to how parents parent their children.
Thank you very much. Dr. Hawkins, your next question, please.
My question is for Mr. Lyons. Historically, we've been slow to unseat city judges in this town unless there's been a problem. Typically, so most campaigns are successful unless there's a problem, which means the bar typically lines up behind a challenger who is typically successful. Do you see this as a case where there is a problem that for change, or is it simply that you believe you're the better candidate?
I think that there is a problem that needs to be changed. I differ significantly with Judge Ritchie on the use of illegal drugs in the children. Our decisions as judges affect children's lives. We have to look at the best interest of the children. When illegal drugs or legal drugs used unlawfully are present, they have to be considered, and you can't ignore and not allow admissible evidence related to drug use, not even allow me to admit it. And it's got to be admitted, it's got to be weighed, and then you make your decision as a judge. You don't simply ignore it.
Thank you. Mr. Jonas.
Okay, this question is specifically for Mr. Lyons. You stated in your introduction that approximately 40% of your practice is based on family law, correct?
That is correct.
Okay, so how many seminars have you attended on family law topics?
I've been practicing for 21 years. I actually have no idea. I have written at least 8 different articles that have been published. I just think it's 8. It's on my website. I don't, it's at least 8, I believe, on family law issues. I have attended, I would guess, hundreds of hours of CLE, but in 21 years, you know, I couldn't tell you how many. The state bar has records. I just don't know.
Steve, just quick follow-up. So, Mr. Lyons, what motivated you to seek judicial office in this election?
In part, it's something that my wife and I have talked about for the last 8 or 9 years. And in fact, when I made the decision, my children were like, well, you've been talking about it for the last 8 or 9 years, it's time to do it. Part of it's also my parents. My dad died in 2006, he's a rural pastor here in Pahrump at that time. My mom just passed away this last year. And in reflecting on my life, I looked at what they gave the community, and I think we have an obligation to give back to the community what we have been so graciously given.
Thank you very much. And Dr. Dupree?
This is for both candidates. What do you consider your greatest strengths to be and your worst weaknesses in deciding the future of children?
Mr. Ritchie, would you go first? You have 1 minute, please.
I think that the greatest strength I have is a commitment to a consistent approach to my job, meaning I read all of the papers that are filed. I try to carefully consider the legal arguments and the factual issues that are presented. I try to give every case the same consideration and with diligence and applying the appropriate law. I go to work every day with that attitude. It's something that I think I owe to the community, and that systematic approach, I mean, one of the reasons why I love this job and why I want to remain in this job is that I still have that feeling every day to come in and serve and read and review and help folks get through difficult disputes. And that consistent effort, that dedication, that passion for folks is what I think is my best qualities as far as handling family matters.
Thank you. Mr. Lyons, same question. 1 minute.
I'm a 5th degree black belt in Taekwondo, and one of the issues with Taekwondo is it teaches you certain tenets that you live your life by. And I think it's the group of tenets that is focused is my greatest strength, and that is courtesy, integrity, perseverance, self-control, and a dominant spirit. And you reel that off in every class that you bow in, but it has to have a meaning to you, and that meaning guides your life. And the integrity to make the right decision, the strength to carry through and do the extra hours of work that it takes. A law practice or a judgeship is not an 8-hour job. They're an 8-hour job, and then you do 4 or 5 hours of work every night to keep up with it. That strength and integrity to do that, to look at the litigants in the eyes when they can't make the decision that needs to be made and say, this is the decision that I'm going to make, and this is the basis to make it. My greatest weakness, I think, is quite frankly that I care too much. I've stayed in cases well beyond when I should have, because I knew that if I got out of the case, bad things were going to happen to my client.
Thank you. Judge Luke, your turn.
Thank you. I think you probably have heard before that I'm not going to be voting in on the endorsement or even debating with the other fine panelists we have here. My question is simple. We have a finite number of courts or judges because of budgetary and space limitations, yet the caseloads keep increasing. And so what structural changes do you propose for family court, or what specific programs would you like to do to cope with increasing caseloads, and of course also the fact that we have a high number of pro se litigants and you can't afford extensive litigation costs?
Mr. Lyons, 1 minute, please.
One of the programs, it's a pilot program that's starting, is a mediation for pro se litigants involving property issues which previously has not been available to them. My only concern with the program is it's not being, it's being run by people that are not trained lawyers that practice in family law. I think that change needs to be incorporated in the program. And I think that would be a beneficial change, would help ease the court system. The other issue is Core CPU 16.2, which is Nevada Rule of Civil Procedure, Rule 16.2. And that's an early case management conference where they can actually meet with the litigants and the opposing and their attorneys and try to settle the case and try to give them guidance as to where things are going. And I think too many judges don't actually use it as an opportunity to settle their cases at that stage.
Thank you. Mr. Ritchie.
Every civil domestic case that I have, I hear within 90 days. I have active case management dockets in which I meet with the folks, and I see the folks that are unrepresented or folks that have very limited assets, and at that time you can divert them either to a short trial, which we have every week, or to the UNOD program, or to private mediation, or to senior judges that are volunteering and work each week to try to settle cases. Every one of those is an excellent avenue to help folks have an option to do something other than litigation. But we have to have a key principle in place, which means that folks that do have a civil domestic case can get in front of a judge and can get a ruling and a decision from a judge if it's necessary, and as quickly as possible, having discovery. And you and I have talked about this for years and years when you were on the bench, that the blend of having judges who are actively managing their cases and getting them in front of the court with the opportunity to refer cases to alternative ways to resolve matters is the best way to serve our public.
Thank you, sir. Perfect timing. Mr. Lamb.
This is for both gentlemen. In the case of veterans and veterans returning home, is adultery a grounds for a faulted divorce? And if so, does that faulted spouse rate child support, or not child support, pardon me, but alimony? And I both gentlemen ask questions. Judge, would you start first, please?
Yes, there's been a policy that we have no fault divorce in Nevada. And we even have a Nevada Supreme Court case called Rico versus Rodriguez, in which a person whose wife had had a relationship outside the marriage, the Supreme Court said that fault is not a basis to deny alimony. I was here earlier and they were talking about spousal support considerations. You're required to make findings concerning duration of marriage, financial circumstances, work histories, and other things. And the Supreme Court and the legislature have decidedly said it should be an economic analysis. That makes it very difficult in those type of cases because alimony in history has been a fault remedy. And so we find something from common law in which adultery was a complete defense to alimony, like in Virginia, where I've been a lawyer for 29 years. You do not have that decisional law or the statutory basis to deny alimony on that basis here. And I'm required, as I took an oath, to follow the laws in the state of Nevada, and so I would not be allowed to deny an alimony claim on the fact that there was adultery during the marriage.
Thank you. Mr. Lyons.
Nevada is a no-fault state. The interesting issue with adultery is where one party spends exorbitant funds while committing adultery. They take trips with their spouse, or not with their spouse, with their new girlfriend, etc., that they didn't do with their spouse. And you can recapture that through a doctrine called community waste. But as far as adultery affecting alimony and other factors, because we are a no-fault state, just as Judge Ritchie said, you can't weigh that into that decision. It is an economic decision set forth in a series of factors by the Nevada legislature now as the factors you need to consider, which goes, what was the person's career before marriage, what was their career after marriage, did they get any education during the marriage, was one parent a stay-at-home parent. You need to look at all of those different factors and make a decision. And unfortunately, adultery is not one of the factors that we're allowed to look at by statute.
Perfect timing. Thank you for being so prompt, both of you. Mr. Melendez.
This is a question for both candidates. There's been a lot of controversy in the family court of late, a lot of stuff going on in the press. My question has to do with the transparency of potential conflicts that may arise. We're a small community, small legal community, whether it be from campaign contributions, working with other attorneys, working with people in this community. How do you address that in your courtroom, or how would you address that in your courtroom to make sure that the people that are in front of you understand whatever relationships you might have that might impact or potentially impact a case?
Mr. Ritchie, would you take, yes, Mr. Ritchie, please take that first.
A judge is required to know their ethical boundaries and their requirements. If there's even an appearance of bias, obviously an actual bias would be a financial relationship or familial relationship. You're required to make a disclosure on the record to give them an opportunity to raise an issue of bias. They can file an affidavit saying that there is an appearance of bias, and the judge has to answer it saying whether there is an appearance of bias or not. It's better to err on the side of making a disclosure than not. I was on the Standing Commission for Judicial Ethics for 8 years here as a judicial member, and judges get in less trouble by making a disclosure. It's funny that Mr. Lyons and I are in the process of an election at this time. It creates all kinds of hazards as we raise money from lawyers and other folks. And the Supreme Court has tried to help weigh in on when would a disclosure be required in that circumstance. It's a very difficult matter. we don't want there to be any appearance of bias. And as far as the controversy in the court, transparency is always a better matter. I became a member of the court and was interested in the family court in 1996 to 1999, when the initial court that was established in 93 was under a tremendous amount of scrutiny in the legislature.
I'll give you a minute.
Sorry about that. I'm
That's
sorry.
quite all right. And you get passionate with these answers and you want to get as much information out as you can. I've been there. I'm sitting in that chair you're in, so I get it. That being said, I'll give the same amount of time to you, Mr. Lyons.
Thank you. I was just in court where actually this last week, where the judge disclosed that her husband had a relationship with the defendant in that particular case. And it's one of those things that, and based on that information, we weren't able to determine whether there's an actual conflict. She actually didn't know the full extent of her husband's relationship. So she's going to file a declaration, and then we'll research the case law and make the appropriate motion as to whether the judge should be recused. It's highly important that litigants have a fair shot. And not that a judge that recuses himself is unfair, but it's the appearance of impropriety. There's nothing more important that a judge can do than to maintain your judicial honesty and your impartiality by disclosing these potential conflicts. And judges that don't should be sanctioned severely. And the public has to have ultimate trust in what a judge does.
Very good. Perfect timing as well. Mr. Blanchard will ask the last question, gentlemen, and I will give you a minute, 30 seconds to respond.
First of all, I want to thank both of you for coming, and Judge, for you running for re-election after knowing what you know, and Mr. Lyons for running for knowing what you don't know. Let me just ask you if you give us one closing quality that you have that makes you the best candidate for either remain in the seat or to become the new judge.
Mr. Lyons, 1 minute, a minute and a half.
Well, I think I kind of already answered that with my background as a martial artist, but I think along with that you have judgment. And having been a practicing attorney for 21 years, having dealt with individuals throughout my career that are devastated when their families break up, with the effect that it has on their children, having dealt with employees that have lost their job, having dealt with people who's watched their houses just erode to where they're totally upside down, they're financially devastated, having done bankruptcy where these people's lives they're trying to put their lives back together. That experience gives you the judgment to make the rulings when families can't resolve their disputes, which is your obligation as a judge. You kind of can't separate the two of them. The background is as important as the knowledge that it has taught you on how to deal with those difficult issues. And I believe my background makes me the best candidate for Department H.
Thank you very much. Mr. Ritchie.
I applied for this position and have worked in the court for 14 years. I think it's one of the most important courts in our community. It's not perfect and it needs to be reviewed and improved. Not only have I managed the civil domestic docket and done the best job that I could over those years, but I've also tried to help the court improve. I was the presiding judge of the family division, selected from 2006 to 2008, and I was selected as the chief judge of the entire district, all 52 judges, and was the chief judge from 2009 to 2010. I participated in the legislative sessions to advance the independence of the judiciary and the accountability of the judiciary. I think that the family court, warts and all, is essential to serving the families in our large community. And I'm not near done in working for those families. I appreciate your support, and I thank you for inviting me to this forum.
Thank you very much, Mr. Ritchie, Mr. Lyons, and panelists. Give our candidates for Department. I know that Veterans in Politics would like some photographs of you in the back. Am I correct, Karen?
Yes, sir.
And,